would someone like to advise the court
Yes, Your Honor. So, I had filed a motion in June asking for a laundry list of items, of which I withdrew all of those but the issue of transportation, and that's who's to provide transportation for my client's parenting time. I have drafted a parenting plan per the Montgomery County court rules. And per Mr. Dean's request, he wanted to make sure that they were the rules in place when it was journalized in October of 2019. I have called and talked to the head clerk, I believe her name was Becky Dye, who told me that she is in charge of updating all of the court rules and has been employed there since January 1st of 2020, and that nothing has changed since that date. So there is a journalized parenting plan that I have sent to Mr. Dean, waiting just for his review, and I think probably waiting for the outcome of this hearing today on transportation.
Okay. Would you agree, Mr. Dean, that the remaining issue is in all likelihood one of transportation?
Yes, Your Honor. There may be an issue in the formatting of the journal entry, but part of the problem with Montgomery Court rules is that I can't even find them online. I'm not. Ms. Sullivan, what did they even send you?
They sent me the rules. They're online. I'll be honest, I had a staff person pull them off, so I don't know how they located them.
Every time I go onto their website and hit their local court rule link, it just gives an error. And I've tried it through a couple of different methods, but in any event, so.
And they may have called and gotten them. I didn't do that.
I'm confirming those, Judge, and I think it made it. I'm assuming I don't have any belief that Ms. Sullivan would misrepresent those, but I think I may have a proposed slight modification to the just the way the journal entry is formatted.
Okay.
That shouldn't be a big issue. So yes,
well, let me get ruling on the transportation. So Ms. Sullivan, what is the issue and what is your argument?
So, Your Honor, my client is diagnosed with epilepsy and does have seizures on a fairly regular basis. Matter of fact, she was just in the hospital last weekend.
Okay.
She does not have a driver's license. She does not have a vehicle. Since she has lived in Augusta, which I think is about at least 3 to 5 years, Mr. Moyer has provided the transportation for the parenting time. There have been a few times where he has assisted her in getting to Emporia to have her parenting time, but for the majority of the time, he has brought the child to Augusta. In return, she has provided some assistance with gas, with car repairs, and car maintenance over time. And so I asked her to quantify kind of how much she thinks that is, and there were some large purchases. But for the most part, she says she thinks she's giving him $20 to $30 a visit.
The hearing opened with attorneys debating court rules and parenting plans. The central issue quickly became clear: transportation. One parent, unable to drive due to epilepsy, argued that her ex should continue providing rides so she could exercise parenting time. She reminded the court that he had been doing this for years, often bringing their child to her home in Augusta, while she helped with gas and car expenses when she could.
I will note that her income is roughly $80 a month, plus a couple hundred in child support. But she is willing to make that part of the order that she pay him $50 a month to be used towards his share of transportation so that she can exercise her parenting time. And I know his argument is it isn't fair. He doesn't get child support, which SSI is considered welfare for the purposes of calculating child support. I will note he does get all the tax deductions, so that's not a lot, but it's a little bit. So I know his argument is it's not fair. He doesn't want to be held to this, that he's doing it out of the kindness of the heart, but he doesn't want it to be a court order. My bottom line, Your Honor, is this is about what's in the best interest of the minor child. And what's in the best interest of the minor child is that she have parenting time with both parents, that she have a relationship with both parents. And because of my client's disability, it is very difficult for her to provide transportation. That she would be dependent on the kindness of others to provide that when he could do it. And again, even though she's under no obligation for child support, nor should she per the guidelines, she is willing to accept an order and to pay him monthly to help facilitate the cost of bringing the child to her the basically 2 times a month of parenting time, alternating weekends. And then there is an agreed upon holiday schedule.
Are there no grandparents involved whatsoever?
There are not, Your Honor.
Okay. Mr. Dean?
Your Honor, I think my client's position is why are we rocking the boat that doesn't seem to be having an issue? Yes, one of the primary issues is I don't want my client. Yes, she has a disability. We acknowledge that. She has limited income. We acknowledge that. She's living where she's chosen to live. We're not objecting to that. My client has been helping with transportation.
I can't remember where your client lives. Is he in Madison?
Yes, Your Honor.
Okay, go ahead.
Both parties moved away from Montgomery County after that, I believe. I'm not sure on the timing. Ms. Moyer may have already actually moved away from the Montgomery County area at the time the divorce was being granted in 2019. Irregardless, neither party lived in that county any longer. The child was residing in Greenwood County, in Madison, with my client. That's why parties ultimately agreed to move jurisdiction to Greenwood County. My issue with coming in and adding that as an additional obligation, since the finances all fall to him to begin with, is putting him in position of being in some type of a contempt for not being able to make his schedule always work. The parties have been, I think, generally I don't do this, but my client sent me an email, and I think he probably summarized it as well as I could, that he and Tiffany have been working really well on this. He takes their daughter to their mother, and I pick her up. Tiffany helps when she can, and I understand she's on a very tight income since she's on disability. I don't do it for the money. I do it so Liza can have a relationship with her mother. Her seizures have gotten worse.
Her attorney stressed that this was not about money or fairness between parents. It was about the best interests of the child. Without reliable transportation, visits would be impossible. The father's attorney countered, saying there had never been real conflict over transportation. The father had always stepped up, even adjusting visitation when hospitalizations interfered. He argued that locking him into a rigid order could risk contempt charges when emergencies came up.
She was in the hospital, taking my ambulance to the hospital 3 times. The last time they kept her until yesterday. She's been injuring herself from falling and hitting herself on things. But this allows him to basically, he also works with changing around that time. This past weekend, with her being in the hospital, he's moved the visitation time to what would typically be his weekend so that they can spend time together. Doctors are working with her to find a way to control her seizures. That being said, he would just prefer it to stay this way. She helps when he can. He does what he can to make sure that they have visitation, because he knows that Tiffany and Liza need to have a relationship, and that they only can have a relationship by having that visitation. This is something they've been doing themselves. I don't know why we need some specified order, because that order is constantly going to need some type of modification given the various issues that are specific to this case.
Ms. Sullivan, why is it your client has chose to live in Augusta?
Your Honor, she actually has another child and has lived in Augusta a significant amount of time. She, I don't think, ever resided in Greenwood County. Frankly, they both moved away from the marital residence. She has a lot of resources in Augusta in that she is plugged in with community mental health and doctors and EMS. Plus, she has this other child, and Dad has a significant amount of parenting time. So her ability to move outside of Augusta is problematic.
Okay.
I will also say, Your Honor, kind of as a follow-up, the reason this is an issue is because the current journal entry requires my client to provide half the transportation, which we all know is not happening. The other problem I have is, while Mr. Dean represents that everything's going fine, and I would say for the most part right now everything is going fine, my child did not see the child My client did not see the child from Easter until June when we came to court on these motions. So just prior to that. I will also note that the journal entry, which I frankly do not like the language, has an out that he can terminate or cancel parenting time as he sees fit per her health issues. So he has this protection if his fear is he's got to cancel a parenting time thing because she's in the hospital. So what I don't want to run into is a situation where my client goes another 2 months without seeing the child, and he can stand there and say, well, the journal entry requires that she pick up the child. She hasn't picked up the child, so you snooze, you lose. That's what I'm trying to avoid, Your Honor.
Okay. Well, I mean, anybody can file a motion for modification. I think what ended up happening is they tried some simple, cheap mediation that did not work. And I think what the court said was, we've got to have some specific orders that were, you know, the most recent court orders as it related to parenting. And so it was codified and needs to be journalized, and then people can file appropriate motions for modification of that. But so, I mean, if you're talking about removing language, that's, you know,
that's in the journal.
I guess you're asking to remove language or add language or just modify language as it relates to transportation. And
yes.
And
Your Honor, that language,
he's not getting any child support. And he has the expense. And I do understand Mr. Dean's argument about if something comes up, or he has car problems, or that you could have him found in contempt by not providing transportation.
But Your Honor, I would say I can't, because the journal entry to create divorce is clear in that it says that he has the right to cancel parenting time.
Okay, well, I agree with you. That's not a very good provision, but it favors him. So, Mr. Dean, I think I'm going to adopt. He's currently, as a de facto situation, he's providing transportation, but she needs to be sure and pay him a minimum of $50 a month for that transportation.
And Your Honor, I'd request
and if they don't like it, they can file a motion to modify. You know, he runs the risk of her filing a motion to modify that provision that gives him the right to cancel visits because it conflicts with the child or with him, or his vehicle's in the shop, or I don't know what. He doesn't have enough gas money.
Your Honor, there was, I don't want to skip over this. There were specific findings made by the court on evidence presented, unrebutted, to that district court judge for why he or she, I don't even recall who the judge was, put those provisions in. So I don't believe that we should just be disregarding them as some overreach. That was presented by the appearance of the journal entry.
Well, she's not asking that be modified. I'm not modifying that.
No, I understand.
In an evidentiary hearing. I
understand. I think it almost seems to be presented by the opposing side that it's just some kind of fanciful thing that was granted to Dad in this circumstance. There was a reason for it.
Okay, well,
and we're not wanting to get into that,
but I'm sure there's a question about ability to care sometimes, and through no fault of her home that I'm aware of. But you're right. I haven't heard all of it, but I really feel like there's got to be some kind of record of what they've been doing and a record for transportation. And I'm, allowing without you having to prove a material change of circumstance to file a modification to modify this standing order that was in Montgomery County. But hopefully just this journalizing and a little bit of additional language to make sure that she is getting pretty regular visitation like it's awarded, unless there's a good reason, takes care of stuff for now.
Your Honor, I would request that we make that through the payment center, that $50 a month.
Well, then he's going to get 3% taken off of it.
Okay. Well, we can direct it.
So DCF, he must not have ever gotten any DCF assistance, and so nobody's ever pursued child support.
Parties agree. He agreed not to. He didn't request child support.
At the time of the journal entry, he could have pursued it. At this point, SSI is considered the same as welfare, so it's a 0 on a worksheet.
Well, that's true.
And
but let's just let them keep caring about each other and the child and see how they do, please.
The judge pressed both sides. Why had the mother chosen to live in Augusta? Why wasn't extended family stepping in? In the end, the judge found middle ground. The father would continue providing transportation, but the mother would contribute $50 a month to offset costs. The ruling ensured their daughter's visitation could continue while recognizing the mother's health limitations. The judge closed by urging cooperation, reminding both parents that the real focus must remain on their child's relationship with both of them.
Okay.
And then if they have a problem, come back to court.
And I will say, Your Honor, I think for the most part, except for my concern over this transportation, things have been going smoothly.
Okay.
For these guys.
Okay. All right, and then you're going to try to get that journal entry ironed out and go ahead and modify it to include the transportation ruling of today.
Yes, I will, Your Honor.
As an additional provision from this hearing. Anything further today?
No, Your Honor, I can let the court know that I also have now gotten a copy, and I'm going to assume, Ms. Sullivan, that your office did call, because that's what I had to have my assistant do, call, and I'll check that, and I'll get you a revision. Apparently, they don't have it. I don't believe they're online. So.
Okay. Well, everyone, thank you for your patience, okay?
Certainly.
Throughout this case. And